Welcome to this episode of the Justice Team podcast. And today we're talking about discrimination, whistleblower verdicts, and how a very special trial lawyer got a big verdict and used AI in some of the techniques to get it. So we're going to walk through practically how she got that verdict, some of the hurdles, and welcome to the show, Michelle Irusso.
Thank you, Bob. Thanks for having me.
If you're just listening and you want to see, of course, we have the YouTube page, but she was also on an episode of Bourbon of Proof where we got her whole story of being a bartender slinging drinks in New York and then actually going to film school, right?
Yep, film school, NYU.
Now she's directing trials and she's the lead actor, the producer, the executive producer, the writer, all those things. Any questions for Michelle or anybody, go to justiceteamnetwork.com and we will get back to you. So Michelle, let's get into this. You had McCann, who is your plaintiff, versus a nonprofit up in Santa Barbara.
Yeah, I have done a lot of nonprofit whistleblower cases. It seems to be a nice niche.
But I just want to know did you talk to the jurors about, you're in Santa Barbara, which for any of our listeners don't know, trying cases in Santa Barbara is pretty much, you're going to get a defense verdict.
I think that's what the defendants thought. I think that's why defense counsel pushed so hard and offered so little as we were going through the litigation.
And I think I read somewhere that your plaintiff actually, she had prior counsel before you even got brought in for the trial in 2019, but she had prior counsel that was trying to get her to take a $250,000 offer and then actually got out of the case because she refused to accept.
That's correct. Yes.
Wow.
They did a motion to be relieved. She had something like 10 days or 15 days to get new counsel. And it was right at the eve of trial. I'm surprised that the judge granted it, quite honestly, because it so prejudiced her.
So, what did they do during those times where she was unrepresented? Any defense dirty tricks?
Of course. The defense dropped about 1,000 pages of emails on her that should have been produced in litigation. So at that time, discovery was closed. The HR director had been deposed. Her manager, who was in some of these emails, had been deposed. And then her manager's manager, who also was, saying nasty things about her in the emails, wasn't deposed. So when I came in, I tried to reopen the discovery, tried to re-depose that manager, and the judge said nope. Wow.
So fast forward, what was the verdict in this case?
The verdict was $2 million for past pain and suffering and $1.25 million for future pain and suffering.
Wow. Plus attorney's fees.
Right. So I'll bring a motion for attorney's fees and costs.
Wow.
And I got a donut for the punitives.
Well, yeah. The punitives I could see. It's a nonprofit.
And that's what the jurors said.
Okay. What I want to know, how are they able to award $3.25 million for an individual against a nonprofit that's doing good things in their community?
Well, that's the thing. There was a lot of evidence that the nonprofit actually wasn't doing a lot of good things. Wow. So there seems to be, and this is why I get called in for a lot of nonprofits. There is there's a mission statement and there's a bunch of people who are like, we're going to do all of these good things, right? And you've got people at the top who are getting paid, hundreds of thousands of dollars. I did a case against the Los Angeles LGBTQ Center. Their top gets paid like $625,000 a year.
I thought,
something crazy.
Like all these nonprofits, I'm on the board of some of these nonprofits, but we don't get paid anything. We just do it for free.
The board, right? You're not getting paid, but the people that work there, the CEO, all of that, they're getting paid big bucks. And actually, the CEO of Community Action Commission was there for the whole trial, and I'll tell you about her reaction at the end. So basically what happens, so you have these people, they're doing a lot of good work, they think they're doing good work, but it's the implementation on the ground that's the problem. And so in our case, my client was a whistleblower because there were a lot of very specific things that they had to do for the children that they were not doing. For example, there were allegations that they were being served spoiled milk and rotten food. And there were, issues with people not showing up to work on time or taking breaks that were too long, right? So all of these little things, on the ground were problematic. It was a Head Start program. There were kids that had a lot of difficult issues. A lot of them had behavioral intervention plans. So they were dealing with, kids who needed a lot of support. And so sometimes what came out in the trial is that they weren't getting the support because the upper echelons were not doing their jobs and not paying attention and not really caring what happened on the ground.
Wow. So let's go back to, when you get this case, you parachute in on a lot for trials late. They bring in as trial counsel, and you're kind of just given what you got.
Yep.
Right. You come in, discovery's closed.
Yeah.
You get these new emails.
Yeah, and I brought the motion. The judge was like, absolutely not. It was so that we were set to go to trial in December of 2019. I brought the motion. The old counsel, in order to get my client to take the offer, well, I don't know why they did it, but they de-designated her experts.
No.
Yeah, they took away, like I didn't have an econ, so I couldn't put on any specials.
To educate our listeners and viewers, when you're proving damages, when you get these $3.25 million worth of damages, are any of those economic? Like, how do you prove those losses?
Right. Well, typically, especially in a case like this where she's not been able to find a replacement job because she lives in a town of 45,000, typically I would put on, the wage loss, and I would show, okay, here, she's a part-timer. She doesn't have benefits. Back then she had dental, medical, full benefits. And, she had a steady salary. So I would have an economist come in and say, okay, well, here's the value of the benefits. Here's the value of the salary. And, I'd get a nice big number.
Can't use it here.
No. All I had her testify about was the fact that she didn't have a steady job. She couldn't afford dental care. I mean, we really had to
make it a general damage.
Exactly.
Right?
Yeah.
So, was it all general damages?
Mm-hmm.
Wow.
Yep. All general.
All general. So, do you have to use, do you need to have a testifying psychologist or medical doctor to talk in these cases, or can it just be your plaintiff and people around her?
Well, obviously I didn't need to because it didn't
I know. And that is the answer for a lot of our people. It even says, well, I know in the California jury instructions of their damages is you don't need anyone other than the plaintiff to prove their emotional damages.
Right. And one thing that I did is I blanketed Lompoc. This was the witnesses, everything. They lived in Lompoc. I blanketed them with subpoenas. I spent thousands of dollars and had hours and hours blanketing them with subpoenas so I could get people to come. I had a lot of witnesses who did not want to participate. They did not want to come. And I had to ask the judge for bench warrants. It was hardcore. But what I was able to get out of pieces of these hostile witnesses, even though they didn't want to be there and even though they weren't friends with my client, they said, I saw her crying.
Wow.
I heard them say things. I knew she was upset. I knew she put on a tough face. So it wasn't just the client. I was able to take those pieces from the other witnesses, and I think it was helpful to me that they were adverse.
So, walking our listeners and viewers through let's talk about the whistleblower cases.
Sure.
What are they? How do you have to prove them? And then what building blocks do you need to prove your case?
Sure. So there's a variety of whistleblower protections. Some are for people that are in healthcare specifically. And then there's just kind of the general 1102.5 whistleblower. So basically what you need to show that your person either did or contemplated or they thought they were going to raise an issue about something that's illegal. I've had whistleblower cases that are about crimes. Right? Just straight up like, okay, this person is drunk driving on the job. Or I've also had whistleblower cases that are more about, and this is the nonprofit issue, how they're spending their grant money, whether they're fudging audits, that kind of stuff. So there's a lot of those cases. And really, it's black and white sometimes about the whistleblowing, right? Because you have the email, you have we can't do this isn't right. Why did you omit this information from the audit, right? So that's black and white. The harder part is figuring out the nexus between an adverse employment action, which means a demotion, not getting a raise, something like that. So the whistleblower part itself can be pretty clear, but then you've got to go and build up.
So do you have, if you have a whistleblower, what are their damages if they just come to you and say, hey, I saw this at a healthcare setting, they were fudging the grants, they were underreporting their losses, they were spending the money directed here. I have email as proof.
So for them being a whistleblower in that situation without an adverse action by the employer, nothing.
So they have to then have to have been demoted or fired. Like, what are things that have to happen to them?
Right. So demoting, firing, sometimes projects are taken away, which takes away the ability for them to advance in their career.
Oh, okay.
There can be a lot of things. Maybe, if you have somebody who, I've had one case where we had a manager who was overseeing a very large a very large group of workers who were very highly skilled, right? And it was a high profile position within the company. And then she whistleblows, and then they kind of put her in the back. Same position, same pay, but, she's not doing the things that are, making the company bulletin, and she's not doing the types of work that are going to get her, to the next step. Like those kinds of things. And that can be hard because it's not really clear all the time. You've got to put it together with a bunch of circumstantial evidence.
So do you said you have to prove that they were fired due to, or these things happened to them due to the whistleblowing?
Yes, it has to be a substantial motivating reason.
Wow. So what does that verdict form look like?
So our verdict form was long. We had 16 questions because it was a combination of racial discrimination and the whistleblower. So actually, yes, our substantial motivating reason was for the racial discrimination. So basically, we went through and asked, was she discriminated against? Was she harassed? And then, did she disclose violations of state and federal regulations? And then at the end, it was, was she fired because of her race? Was she fired because she was a whistleblower? And then, they have to ask, did the defendant prove by clear and convincing evidence that they would have terminated her?
Oh, so there's a rebuttable presumption if they get there that the defendant has to then prove the adverse?
Right. So for the whistleblowing, they have to prove by clear and convincing evidence that they would have taken the adverse employment action anyway.
Wow.
So what we had in my case was they had said, my client had taken a video of it. Well, do you want me to tell?
Sure.
I want to back up and tell the story of the case?
Yeah.
Because it's hard to explain without. So my client worked at Community Action Commission of Santa Barbara for 16 years. She was a lead teacher at one of the centers, and she was known to be a very tough teacher, which was good for a lot of children who were difficult because she provided them with structure and helped them work through some of their behavioral issues. So no write-ups, no nothing until about 2013. They give her a bad performance review, and they talk about like her tone, right? A lot of it's like her tone, and she's like, I'm just very forthright. I'm very direct. This is my culture. Well, those emails that they dropped on me, the managers were like, I'm so tired of hearing about her culture. Is she going to complain anymore? Is she going to, what is her culture? What is this? And so she gets the bad reviews. She keeps making complaints. She's making complaints all the time to the appropriate licensing agency. She's calling anonymously because she figures out that the licensing agency is calling her supervisors. They're pretending that everything's okay, and so the reports are not going through. So she's doing all of this. People know that she's complaining. She gets a negative performance review. She gets another negative performance review in 2014. She's super, super stressed about what's going on. At that point, there are people in the workplace that are calling her a black rat, a black gorilla. She's a very dark-skinned black woman, probably about 5'10". And, this is really affecting her morale. And also it's affecting her because when she needs help in her classroom, they're not helping her. And again, these are kids. Some of the kids are physically violent. Sometimes you have to take the other kids out as you're dealing with one child who's having a crisis. So, you need backup, and she's not getting it. So she goes out on stress leave. And while she's out on stress leave, there's one particular child that was on the other side. So there's 2 classrooms there. And management decides that they're going to move the child to her side. And rather than have a meeting with her to go over the child's behaviors, how to handle her, et cetera, they're like, nope, we're just going to move this child. She says, I'm begging you, don't do this. She has a letter that she sends to like all the management, and they're like, we don't care, we're moving the child anyway. What happens? The child has a crisis. None of the people will come and help her. She's screaming for help from everybody. Everybody's like, nope, I'm busy. Nope, it's your turn to deal with this kid. No, I'm not going to do it. And in desperation, she takes out her camera and films the child. She wants to show that she's not the one harming the child because the child is being violent. It could be bruised. And she also wants to show, there are behavioral interventionists that they work with. She wants to show the behaviors to them and be like, hey, how do we deal with this, right? So first the program director over all of these centers, there's like 25 centers. This is a $25 million operation. This is a big nonprofit. So first the program director sends a letter to licensing, says, oh, we suspect child abuse. We think, Ms. McCann abused this child by verbally yelling at her. Now, the person who made the complaint about Ms. McCann verbally yelling at the child was the woman who was calling Ms. McCann a black gorilla.
What?
she was asked to come help during the crisis and she said no. And then a bunch of other teachers said no. So the child abuse didn't go anywhere. Nobody believed that Miss McCann abused the child. But then they decided, oh, it was the video. The video was the worst thing you could have ever done. Because the child was taking off her clothes, not during when she was being videotaped, but they're like, oh, the child in distress, you can't ever videotape her. That's the worst thing ever. So as we go,
we live in 2023. It's like everybody's videotaping everything.
Right, and part of the work, this is what came out in trial. Part of what they do with the children for their behavior is to videotape.
Oh, come
them.
on!
Everybody videotapes.
So you're in Santa Barbara. How many? Did you have any black jurors even on your pool? No,
not one.
It's just Oprah's the only one.
Yeah,
I think she's the only one.
Oprah and Meghan Markle, my birthday mate.
Look at that.
Meghan, and Barack Obama, August 4th.
That's a good day.
It is a good day.
My youngest is August 8th. Just missed it.
Yeah.
Oprah's actually born on my birthday, January 29th.
Really?
Yeah.
Wait, so is that Capricorn or no? Is that?
We're Aquarius.
Aquarius. Okay.
Don't insult. Sorry. Don't insult me. And Tom Selleck and my twin brother Brad. All right. Anyway, and Heather Graham, I believe.
Really?
Older girl.
What happened to her?
She's still around, I guess.
Is she?
I don't know.
Boogie Nights is such a good movie.
Yeah,
anyway.
so, did you have a jury consultant?
No.
Wow.
I had nobody. I had just me.
Yeah, so that's, I want to get into this for our listeners because a lot of people are true solos out there, lone wolves that don't have a lot of support. And, sometimes it's hard to find support in cases just because people don't believe that the case is a winner. Right.
I did have some co-counsel back out. And my client had a very hard exterior. She was hard to work with.
Yeah.
It took me years to gain her trust.
Because, I assume 2019, you got pushed into COVID and then you were in the abyss.
Correct. Yes.
Wow.
2019, we were set to go, I think, April 20th of 2020. So I go in there, we do motions in limine December 2019, too close to Christmas. We continue it till April. Then the pandemic happens. And then in 2021, we got set for, I believe, 2022. I went in 2022. I was up in Lompoc, again, blanketing with subpoenas, getting the witnesses. The defense continues it. And then we finally get done at 2023.
I was doing I'm going to do a live story.
Oh.
No, I'm just kidding. I wasn't
I'm
gonna do
like,
that.
what?
But I want to see how this looks if I just videotape this at the same time, like multitasking. Look at that.
It looks really cool.
Yeah, we're here live. People will listen to this later. So there you are, lone soldier, trying this case all by your lonesome. How many weeks was this?
It was 2 weeks. I had to cut the witness list down because by the time the judge actually let us try the case, she's like, oh, by the way, I'm going on vacation. So if you don't finish, I'm declaring a mistrial.
Well, that's always nice. Who's your judge?
Donna G. Geck.
No, I don't know that one. Yeah. So what are some tools that you had to use? You have to be efficient with your time. I assume you're got a team on the other side. So, what tools did you use to try to maintain your sanity?
So during the trial, I decided to go completely low tech. I had gone to the Lanier Trial Academy with a bunch of my JHQ mates a couple of years ago.
Oh, nice.
And I got one of the IPVOs, and then I got the cardstock and the pens that he uses. So I did everything low tech, except my research, I used co-counsel by Case Text.
Yeah, Case Text co-counsel, which they're now giving 10% off. To Just HQ members, anybody with a link, which will drop into the notes here. But yeah, we use Big Believer in that one. How did you use it during trial? I know we would see in the chat that Justice HQ members would try to help whenever you would ask. I didn't know you're there by yourself. Shit, that was really, I felt real bad for you. But what are some things that you used with using AI to help you in the moment? Sure.
So while we were doing jury selection, there were a number of women, and our only women of color, No, we had an alternate who was a woman of color. But so there were a number of women, including our potential jurors of color, and they all had talked about the fact that they were aware of implicit bias and these kind of things, racism in the workplace. They were all three struck. By the time we got to number 3,
I would have done the Wheeler motion.
I
after
did.
One. No.
Well, I did it on the third one because I had done some research before. I said number 1 is not enough. But I was sitting there in the courtroom and I was like, not only are they all women, but they have all expressed an affinity or a sympathy with African American women in the workplace. And so I put in that co-counsel, I was like, can that be a basis for a Batson challenge? And so I lliterally was sitting there as defense was questioning with the potential jurors and like, can I do this?
Wow.
So yeah,
so
I made the motion. I cited whatever case that it had come up with, put it on the record. The judge denied the motion, but at least it's on the record.
Well, and for practical, for our listeners or viewers, by doing that alone, it scares the shit out of the other side. They're not going to do it again.
Yeah.
Right? Puts them on notice.
Yes, but I did end up with a jury of 8 men and 4 women because they got rid of all the women. So, yeah.
Well, it didn't seem to work.
No. What I also used, so my very last day of trial, I had subpoenaed the CEO. She was there the whole time. And I had previously subpoenaed a PMK with some documents to bring for punitives. They objected, but didn't bring a motion to quash. So I was like, okay, fine. I'll subpoena the CEO. I walked over. I said, well, here you go. And we were dark on Friday. So on Friday before the Monday, I was probably going to do this. I emailed them and said, hey, do you want to talk about the subpoena? You want to stipulate to any documents, blah, blah, whatever. 9:18 in the morning, we're sitting in court. I get served with an opposition or an objection to my motion, to my subpoena. And I was like, what is this? And I was like, Your Honor, we should talk about this. So rather than just talking about it, the judge decides that she's going to rule on the objection. That at this point, I literally haven't even read the whole thing because we're sitting in court. Yeah. She rules on the objection, say, no, I think your subpoena is overbroad. And I'm like, can we talk about it? Like, I haven't even had time to oppose it. There's not even I don't have any notice. And she's like, nope, I'm sustaining it.
Oh my God.
And I was like, I literally grabbed my purse, flew back to my hotel room, got on co-counsel and said, can a judge sustain an objection to a subpoena with no notice and no hearing? I printed out the memorandum that I got from co-counsel. I called a friend. I said, I need this to be a motion in 30 minutes.
Wow.
And so if I didn't have that, and I did, I had it. I had the motion in 30 minutes. And only because I had the co-counsel.
You literally used the namesake of the product as the actual use case.
Yeah.
I mean, that's just fascinating. And it just, people, I always tell people they're afraid that AI is going to take lawyers' jobs. They say, no, it's going to take the jobs of those that don't know how to leverage it or don't want to use it or learn.
Absolutely.
I also saw one of your write-ups on our Just HQ boards, how you also did some for your PowerPoints.
I did. So because I had gone low tech throughout the trial, I kept notes for what I wanted for closing. But I figured that we would have a weekend over the closing because defense had a huge witness list and they'd only called 3 people. Mm-hmm. On a Wednesday afternoon, they're just like, we're done. Ugh. And I was like, what? Didn't even call their second expert that I had spent 3 hours deposing. I was like, what the heck? And so, I'm up to the judge. I'm like, well, I'll be ready at 9 a.m. tomorrow morning to close. Shit. Because I had days of testimony that I hadn't gone through yet, and I wanted to do a PowerPoint. So Amanda from JHQ had put out a notice saying, oh, Canva has this new AI stuff, blah, 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 whatever. So I looked at it and I started playing around with their PowerPoint. My God, it was wonderful. Really? So I did a PowerPoint. I said, From Canva. I said, give me a presentation that's a closing argument for a plaintiff in a discrimination case. And it pops out with a bunch of different choices of how you want it to look, the colors. But it has the scales of justice and the opening, background of the case, emotional distress, thank you for coming at the end, right? It has all these pieces and they gave me 10 slides. So I did that. And then I said, give me a presentation on malice, fraud, and oppression. Oh my God. And it popped out and I got this guy with this evil face for that. And then I said, give me slides on a failed HR investigation. And then I combined all of those different things and then added in, my own text. But I had, usually I'm spending hours picking colors and photos and blah, 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 blah. Nope.
Wow.
So I didn't sleep very much that night, but I was ready to close at 9 a.m. in the morning.
I mean, it's crazy. And, I love Amanda. It's funny on the Just HQ, most people love the use case of the media stuff that she does and the updates from Canva or Instagram. And these are quick little hits and things. I didn't know that Canva did that. That's crazy.
Yeah.
Oh, man. It's a brave new world. Okay, so now tell us what happens when you get this verdict. I mean, it's 16 questions. That's a lot. I mean, that usually take people days, the jury.
Yes. Oh, and the fun part, she only gave me 45 minutes for closing. I got cut off in the middle. She didn't give me a warning or anything. And it was such an emotional closing. I was crying. The jurors were crying. I wasn't paying attention at the time. So I didn't get to go through the verdict form with them.
Wow.
At all.
Yeah, that means you got a good jury. You told a good story all the way through. And I do think by the time you get to closing argument, it's just further affirmations for the jurors that are already on your side.
Yeah.
It's just you give arguing them with the tools they need to do. So you said you go low tech and you learned at the Linear Trial Academy, which I think it's always in Houston, end of June-ish?
I believe so, yeah.
So what are give us some of these tips that you use to do that, because I think that's fascinating.
So one of the key issues in my case was a timeline of the HR investigation. My client had complained of discrimination, and then the video incident happened. She complains in July. The video incident happens in November. They don't start investigating her discrimination complaint until after the video incident.
Oh, boy.
So one of the very first things I did on my first day when I had the manager is I wrote down with the IP vote as I was questioning the timeline. And the defense was like, objection, Your Honor, I don't think she can do that. And the judge was like, I think she can do that. I'm like, it's just like as if I had a whiteboard. Yeah. But I kept that, that piece.
So when you're writing this down, just explain what you're writing on in real time.
I'm writing on a heavy weight white paper, and I've got my markers, the Papermate markers. So I'm writing July, beginning of investigation. This. So as the witness is testifying, I'm writing down the dates that they're testifying to, so that the jury can see visually what this looks like.
Very powerful.
It was very powerful.
So are you using this is this butcher paper? Is this electronic? What is this?
No, so it's literally this little IPVO thing that's about a foot tall that sits on counsel table, and that's what I use. I'm writing on the paper. It's like an Elmo, right? Yeah. So, and then it shows it. So that's what I'm doing. And then all of my exhibits I also use paper. So,
but you're writing on your pad that projects onto.
So the court had a screen. So yeah.
Wow. And then you're able to save that, and then you could show it to the jury in closing because it was showed to them. Whoa. Another thing, I do think timelines are absolutely critical in any case. I do a lot of medical cases, and it's when things happen, when they went to the doctor, when surgeries occurred, and also implementing and when defendants were doing things. A lot of lawyers lose, sight that they think by just saying it, jurors are going to get it. It's not like that.
No, especially if you have a timeline that's so stark and so important. I think the visual you can't do without it.
Yeah, and then, there's a lot of people that help you with these timelines. We've used to have to do these manually. Again, these AI products, you can drop them in and ask for a timeline. It'll pick up every date. It's crazy. It's
absolutely
crazy.
So, you reminded me. When I asked Canva for the timeline, I said from July to December. And so part of the timeline, it gave me months, different slides that were months.
Yeah, I've done with the co-counsel product too. I'll just drop in thousands of pages of medical records and ask for just a timeline.
Nice.
Oh, that's crazy.
I've not done that. I've not done that with co-counsel yet.
That's good. You always fact check. I always say with the ethical part of it, you fact check all of it. It should get you 90% of the way there, but shit, that's amazing. All right, so then you get through this 16-pager without even explaining to the jury how to fill it out, which we'll talk about that later. Apparently it worked out for you. The verdict's read, right? Was your client there with you?
Oh, yeah. We cried and hugged each other.
Yeah.
But at that point, we knew so many of the jurors were with us because throughout the trial, they were so appalled at some of the testimony. We could hear them. When they talked about, I didn't start investigating because I didn't really understand her complaints. One of the jurors in front was like, how many times did she have to tell you? And she was right there. So
that's awesome.
Yeah, they were a very, very caring jury. And then I was going to tell you about the CEO. So the CEO is new. She was not there when this happened to my client. Afterwards, she came up to my client, and she was not in tears. I think the word would be verklempt. She was, choking up.
Verklempt. That'll start at verklempt.
I lived in New York for 11 years. And she came up and gave my client a hug and was like, I'm sorry you went through this.
Well, I hope they, compensate her and do the right thing. They're going to have a large attorney, fee bill too. You spent a lot of time on this. Years and years and years.
Yeah.
Wow, that's powerful. So you had, how many causes of action were there? Is it whistleblower on top of discrimination?
So it was racial discrimination, racial harassment, whistleblower retaliation. And I think we had wrongful termination and violation of public policy, but basically it just distilled down to whistleblower retaliation, discrimination because of race, wrongful termination. They did not find that she was terminated because of her race. They found that she was harassed, but they really thought that the termination was for the whistleblowing.
But it doesn't matter for you. all roads lead to Rome, right? I mean, it has to
Yes.
be. Okay, so explain that for our viewers and listeners, what they have to overcome in order to win to get to damages on these types of cases.
So the very first question that we had was there an adverse employment action? And luckily for me, the jury didn't just check yes or no. They put how many voted yes. So it was 12-0.
Oh, wow.
Yes on that. Sorry, I'm going to pull this up right now because I don't remember.
Oh, I love it. Yeah, a lot of people try to spend too much time trying to prove I mean, if you win on one, you win, right? And I think, I try a lot of spine injury cases. People try to prove acute injuries too much and just realize aggravation, pre-existing condition leads to the same place. So, I mean, this is fascinating stuff.
Yeah, we had the defense wanted a much more complex verdict.
I'm sure
they
did.
wanted like a 36-page verdict form, which was ridiculous.
Yeah, confusion is the best friend of defense lawyers.
Luckily for me, the judge, who I don't think was always on our side.
But that's good sometimes, though, because it makes your verdict more ironclad.
Yes. Yeah. There was like, for example, there was some impeachment evidence, and it was just clear dead bang impeachment. And she just looked at defense. She's like, well, I have to let her show it. I'm like, but why wouldn't you? You know what I mean? Like, why is this even a close call? Why do you feel like you have to let me know you have to? Yeah. So the first question was adverse employment action. So that was 12-0. And then next we had, did the defendant believe that she disclosed or would disclose violations of licensing requirements? Again, 12-0, yes. Did she have reasonable cause to believe that there were licensing violations? Again, 12-0, yes. And then was her disclosure a substantial motivating factor for the decision to discharge her? 11-1, yes.
Wow, that's the big one. That's like causation.
Yeah. And then 11-1, no on did the defendant prove by clear and convincing evidence that it would have discharged her anyway? So, we were mostly 11-1.
That's impressive.
But we did have 12-1. They believed she was harassed. 12-1. They believed it was a hostile, environment.
Yeah, and for our listeners or viewers, California need 9 out of 12 in civil cases to carry on any question to go to the next. Doesn't have to be the same.
Right.
9 jurors, as we hear in our jury instructions over and over again. Yeah. So, I mean, Michelle, you settle a lot of not only 6 to 7 figure verdict ones, but you've settled a lot of cases with these same type of nonprofit whistleblower type issues.
Yes.
Right? Yeah.
In December of this year, I settled a case against UCLA. That was
Wow.
a nice, solid 6-figure case. My client was still employed at the time, and that was a whistleblower case. That case was...
What does the government ever step in for you on these whistleblower cases, try to take the case from you to prosecute? Does that ever happen?
No, so that's a separate, that would be like a key TAM case.
Okay.
What's
the difference?
So a key TAM case is basically where you...
And that's QUITAM, key TAM.
That is where you find out that there's some fraud going on, right? Somebody's overpaying, somebody's defrauding the government. In California, you can also do a key TAM for insurance, any insurance, not even just the government. That's a separate statute, but same idea. So the key TAM case, you file that under seal and you give the government your information, and then they have time to determine whether or not they want to proceed. If they proceed, then they take it and you get some small fee. If they don't proceed, then you can do it and you get a bigger fee.
Wow. Okay. Man, this is all, because as anybody knows, we're seeing a lot more cases go to verdict with these type of issues because I think finally the employees are realizing that they have rights.
Absolutely.
Right. So what are some practical things as you're ending out the half-hour session here, some practical use tips for people that want to explore these types of cases? If people are walking to their doors with these types of cases, what are some things they should practically do?
I think first and foremost, you have to be really careful when you're talking to your client and doing intake and letting them know that these are very deposition-specific, deposition-heavy cases. When you have a car crash, everybody knows that there was a car that was hit. It's just a question of whose fault. When you're looking at these cases, you don't even know that there's a there until you start the discovery. So things can get really good and things can get really bad. And so when you're looking at these cases, you really have to decide who are the key people that I need to depose and what are the key documents that I need. And I think getting those depositions on calendar immediately and coming out of the gate with your discovery. I try to get my discovery out in 20 days. So doing that and setting the stage for that, I think, is really important, because you don't want to get yourself heavily into a case and figure out that you don't have a case, right?
So you load up on, rather than just sit stale, you try to prosecute heavy these cases in the beginning to get the discovery in, and then take maybe the key depositions to figure out if it's a case.
Absolutely.
Wow.
Absolutely. Okay. Because, if I'm doing 11, 14 depositions, when I'm spending 40.
I know.
I mean, nowadays, actually, probably 50 grand in depositions.
Well, at least they have the delay pay now on some of those,
Before you even get to experts. So, and it's a lot of time, right? It's a lot of time. It's a lot of energy. We're not doing, necessarily 6-hour depositions. I'm not sitting with an expert for only 1 hour, right? So if I have a psych on the defense side, I might be with them for 3 hours. Like, it's really expensive to litigate. So you got to be careful.
Wow. Michelle, well, thank you for coming on. Go to justicesteamnetwork.com. Any questions about these types of cases, but just outstanding verdict. Thank you for fighting for people like Miss McCann, who I'm sure is so happy right now. She's got to be so happy. Vindication.
She's happy. Her whole family's happy. Her family's thanked me. Yeah.
Wow. So for all of our listeners or viewers, you go to justicesteamnetwork.com, ask any questions, but these cases are becoming more prevalent. And, I didn't know there was a niche for the whistleblower nonprofit arena, but here we have Michelle E. Russo. Thank you, Michelle. Thank you for listening.
Thank you, Bob.